Do lawyers reason with policy, or do they just talk about the law? What is the relationship between legal rules and policies? How should lawyers reason effectively using policies? So in this video, I'm going to talk about policy-based reasoning. My name is Francis Tom Temprosa. Uh, I am a faculty member of the Ateneo Law School. This video is part of the series that I'm producing on legal techniques and logic. This video is for my class, but I'm also sharing this to the public. Lawyers argue using policies. Lawyers make policy arguments. Lawyers argue that a particular result is desirable, for instance, because it furthers policies or public policies. Lawyers argue that the contrary result is undesirable because it would impede certain public policies. We actually use policy here to pertain to another consideration other than the text of a rule or the law. This is on this basis that the court decides, and lawyers actually put forward arguments. Policies are goals that are sought to be achieved in enacting a law, and the way we frame the law is broadly in the sense of the black letter law or case law. So that's policy. But there's really that relationship between the rules and policies. Rules and policies are not mutually exclusive of each other, and more often than not, before the courts, policy arguments are propounded. So let's examine the relationship between rules and policies. The relationship is basically the same as the relationship between means and ends. What do I mean by this? Rules, as they say, do not only exist for their own sake. Rules are means towards certain ends, and the ends or the goals are the underlying policies of the rules. So we can differentiate rules and policies in terms of structure and in terms of function. In terms of structure, policies are often stated in the abstract. That's very common. Rules are often stated or expressed in a very concrete sense, concrete, limited, and contingent sense. Policies tell us that they should be pursued at all times. Rules, on the other hand, can be followed under certain circumstances or not. Note that policies are stated in very specific terms and they take on the characteristic of rules and vice versa. In terms of function, rules create legal consequences, policies don't. So, policies justify the rules but don't produce legal consequences in themselves. All right? Every legal dispute poses a conflict between and among policies. When one thinks about it, behind every law rather, or legal rule is a policy. A court, an institution, or a judge resolves disputes under a particular set of facts and considering policy arguments. So, what are some of the examples of policies in the law? So, an example is a policy of honoring the will of the community, a policy of respecting the will of the individual, policy of adhering to what the law says, that's positivism, policy of looking at notions of justice or reasonableness. Courts, like the one we see here, consider whether they should be concentrating on applying the rules to situations as formalism, only that, or should they be also looking at or deciding disputes in the way that they further policies, that's instrumentalism. So there's always a clash between policies. A good lawyer, through policy analysis, should identify supporting each possible result. A good lawyer should synthesize policies involving two things, so two ways of doing it. A lawyer can examine the relationship in theory or he can look at the relationship and consequences. So for our example here, let's look at Lydia. Lydia is a 65-year-old woman who bought an item from a store, and she noticed that she bought an item on sale, but it was damaged. So she did not know this fact when she bought the gadget or that item. Now, consumer law says, for example, that the policy of the law is to fully protect the consumer. But the letter of the law specifically says that a consumer cannot return an item when she bought it on sale. So, if you were the judge, what should you do? Question is, should you rely on what the law says? Should you just rely on the letter of the law? Formalism? Anyway, she's already a woman of legal age and she bought it freely. This honors the policy of freedom of contract, efficiency, personal autonomy, individualism. Or should you look at the policy of the law, instrumentalism, that is? Anyway, she's an elderly woman, she bought it freely, but the state should look after her as a vulnerable member of society because of social justice. This will honor the policy of paternalism, justice, and the state should look at the welfare of the citizens. As a lawyer, when confronted by these, you should obviously look at the policy arguments on each side. You should embark on a task of policy synthesis to make sure that the policies that you argue for are consistent with each other. Your arguments, your policy, everything should be consistent. You should also be on the lookout for the inconsistency of the other party, and at the same time look at the relationship between your argument and the policy that it furthers. Now, look at this picture here. How should you decide if you were the judge in this situation? So there is really no hard and fast rule, but there are techniques. Two general decisions that a judge should undertake. First is to decide on the relative importance of the policies involved. Which policy is the most important? Second, decide on the relationship between the means to the ends. Will the decision that you decide, the policy that you decide on, do they actually match? Will the decision further a policy that's important? Generally, the more general the policy is, the greater the indeterminacy. So, while judges decide on policy arguments on the relative weight of the policies, there are certain things or other factors that inform the context, that form the context of the decision. First is the historical setting. Specific policies are more important at one time or the other. Second is judicial philosophy or ideology. And all things being equal, the result is supported or related by a policy. That's the one that's going to prevail. All right? So that's about the judicial philosophy or ideology of the one that's designing. Third is the existence of binding precedent or sometimes persuasive authority from other jurisdictions. If they give preference to one policy or the other, it's likely that the judge will also probably give preference to that policy. All right, so that's it. This is just a very short introduction to policy based reasoning. But really, policy based reasoning is one of the greatest techniques of a lawyer. Lawyers should argue based on policies, and judges should decide and rule using policies. There are differences between rules and policies, but there is a relationship between the two. When you think about it, underneath every legal rule is a set of policies. The challenge for the lawyer then lies in policy analysis and synthesis, and of course in argumentation using policies. There are ways on how to decide between competing policy choices, and context is very important in the decision-making process. All right, thank you very much for watching.